Professor Milton, I do not understand why the other experts are not on screen.
Oh, the time schedule is very bad on this other side. Like our side is okay and your side is evening. Others are still in class right now, especially the universities that opened. Okay, we are live now.
Professor Milton,
Let me just
understand why the other experts are not on.
Okay.
Professor,
All right. Dr. Marota, we can
Yes.
set up.
Hello, everyone. Welcome to this meeting that we are going to share related to international residual mechanisms for criminal tribunals and the ICC. As usual, we have the presence of Professor Darwar Kanash Tripathi. He's a professor from Singularity University from India. Also, we are going to have the presence of Professor Rama Gudumela. She's a PhD researcher and a professor in international criminal law from India. Also, Marit Kaur. She's a counsel for the ICC. We are going to have the presence of from Italy from Professor Alessandra Lanciotti and Maria Mercedes Pisani. At the same time, from South Africa, they are going to join us Dr. Ditaba Ranzane. He's the director from Government and Legal Services from the Government of South Africa. Marcela Leso, director from the Government International Legal Relations from the Department of Justice, also from the Government of South Africa. And finally, we're going to have the presence of Brian Rampane. He is an attorney and an international scholar, researcher, and counsel Brendan O'Coat. She's an special expert international lawyer from Sweden. Also, the host is Professor Milton Awar. He's a founder director for the Center for International Criminal Justice Africa, and I'll pass the desk to him. Thank you, everyone who is watching us.
Oh, thank you so much, Dr. Marota. I must thank Professor Sripathi too. Thank you, panelists, for being able to show up. The other panelists I've indicated, a number of them have given reasons for their not showing up. We have Counsel Brenda has just sent me a message. They are busy with a particular case, with the EU case, which has a deadline. And I have also gotten explanation from some of the other counsel who are engaged in teaching during this time. It's a question of global timing. So, but they will be joining us as and when they're able to make it. All right, we welcome you viewers, wherever you are on our platforms, millions of you all over the world. Good evening, good morning, good afternoon. Today or tonight, wherever, depending on where you are, we're going to examine a very critical topic entitled United Nations International Residual Mechanism for the Criminal Court, for the Criminal Tribunals, sorry. In short, it can be IMCT. Sometimes it can be addressed without having to add UN, but we know it came into existence as a result of the United Nations. It's a very interesting area of discourse today, and you are privileged to have here on the panel very experienced professors. As we've told, some of you have been with us. We have Professor Sripathi, who has well over 30 years experience teaching international law. He's a professor of law, well respected internationally. We have Dr. Marota, who is an expert in areas of international human rights law and international criminal law. Myself, I'm the founder director, the way it has been indicated. I hold a PhD in international criminal law. So we're going to discuss this topic for the next 1 hour, and we hope you'll be able to enjoy. I hand over to Marota to be able to usher in Professor Sripathi.
Okay, thank you, Professor Milton, for your participation. Well, today we are going to analyze the functions of the mechanism of the international from the mechanism for the international criminal tribunals. So the question that I, I I give on the desk if this mechanism for the international criminal tribunals sets the highest standards of fairness. What do you think, Professor Milton or Professor Shipati?
I didn't get that question really properly.
Okay, the question
Can
is,
you repeat it again?
yes. Okay, I will repeat again the question. Today we are going to study and we are going to discuss the mechanism for the international criminal tribunals. So my question here, the first question that I bring to the desk is, if you, from your experience, if you see if there is fairness before the mechanism for the international criminal tribunals, the ones that we are have right now.
You're asking whether there is what? There's, I didn't get that
The
last
fairness.
one.
Do you if you see that if there is fairness
Fairness.
before the yes, fairness before the mechanisms for the international criminal tribunals
Okay.
at the way they work right now.
Maybe Professor Sripati wants to attempt that.
Okay, I will. I was always the first one.
I can come later, yeah.
National discourses. Now, hello to the other two panelists as well as the host and the co-host, Professor Milton, Dr. Marota.
Thank you.
And
Thank you.
a very good evening. Since I'm in India, it's evening now here. So a very good evening,
Prof.
to the viewers, wherever you all. Now, the theme for today's international discourse is International Residuary Mechanism for International Criminal Tribunals. Now, in order to understand, it is necessary that we should go back into history. I mean, what was the reason? What was the cause for the establishment of the IRMCT? We'll have to go back to the early 1990s because we are well aware of the fact that in 1990s there were internal wars in Rwanda, in Africa, and in Yugoslavia, in the Europe continent. And war crimes, genocide, and then crimes against humanity were rampantly committed by the heads of states in these two countries. And therefore, in order to bring them before justice, the United Nations Security Council had established two temporary criminal tribunals. In other words, two ad hoc criminal tribunals, that is ICTY, International Criminal Tribunal for Yugoslavia, and ICTR, International Criminal Tribunal for Rwanda. The two courts or tribunals were established in 1993 and 1994, respectively, and they started their function of trying the criminals in the two countries, that is Rwanda and Yugoslavia. And there was a long list of fugitives that the court had to try, and it took quite a long period of time for the court to try and then punish the accused. And the courts were wound up. ICTY was wound up, ICTR was wound up in 2015 and ICTY in 2017. But the courts had completed most of their mandates. In the sense, the main purpose, the main reason for which the two tribunals were established, they were able to complete, and there were only a few residuary functions that were to be performed. And since the courts were likely to be wound up, the United Nations decided to establish an international residuary mechanism so that this mechanism, it's a criminal tribunal, but in short, it is run as a mechanism. So this mechanism was established for the purpose of the residuary functions of the ICTY and ICTR. It was established by the United Nations Security Council in the year 2010. And the although the mandates have been completed by the two courts, that is ICTR and ICTY, yet some residuary functions that had to be completed, and therefore the UN had established this. And the residuary functions such as future trials of fugitives who were at large. If they had been caught, arrested, and brought before the court, the two courts were finished off. They were at large. The courts, the mechanism was there to arrest them, but the thing is, they could not be found. And whenever they are found, they need to be tried. And since the two tribunals were being wound up, the UN decided to establish this mechanism so that it can take up the future trials of those fugitives who were at large, who could not be found and who could not be arrested. And apart from that, the convicted persons by the two criminal tribunals, ICTR and ICTY, may petition for an early release. So if they submit a petition to the court for early release, and if the court itself is not there, then who would pass the order for the early release of the convicted person? So this mechanism was established. So this mechanism would look into the matters of petitions being submitted by the convicted persons. And of course, we are aware that under national criminal laws, if a convicted person behaves properly on grounds of good behavior, the persons are released much before their sentence ends. So probably here also a similar procedure may be adopted by the mechanism, and a person could be released much earlier than the sentence that is passed against him. And then protective orders for witnesses may need to be modified, because the kind of provisions that were provided under the two criminal tribunals probably may not be adequate enough. And since the provisions must be modified, the mechanism was established so that the mechanism will look into the matter of providing further stronger protection to the witnesses. And lastly, the archives that contain confidential documents relating to the court also had to be safeguarded. The confidential documents relating to the two criminal tribunals, ICTY and ICTR, had to be safeguarded. And therefore, if a mechanism, a residuary criminal court is established, this residuary criminal court would take care of all the residuary functions of the two erstwhile criminal tribunals, that is ICTR and ICTY. Now, in order to oversee these functions, the Security Council passed a resolution number 1966. And under this resolution 1996, which was passed in 2010, the mechanism was created, the residuary mechanism. Now, speaking of the mandate of the residuary mechanism, the residuary mechanism shall continue the jurisdiction, the rights and obligations, and essential functions of the ICTY and ICTR. So whatever rights and jurisdiction and obligations that the ICTY and ICTR had or were privileged, the same jurisdiction, rights and obligations would be exercised and enjoyed by the residuary mechanism also. And it also perform the essential functions of the two criminal tribunals. Then the mechanism would be small. This is what the United Nations had thought of at the time of establishing this mechanism, that it would be small, temporary, and an efficient structure, and a structure or institution that would work with limited number of persons, and whose functions will diminish slowly over a period of time. In the sense, the uh, institution would lose its significance and importance as time passes by. And it will continue to operate until the Security Council decides otherwise. Until the Security Council takes a decision to continue the mechanism or not, the mechanism will continue. The day the Security Council decides the mechanism, it would stop functioning. Now, the mechanism or the international residuary mechanism for criminal tribunals has two branches. One branch is established at Arusha in Tanzania, and the other branch is established at The Hague, Netherlands. So all the residuary functions of the ICTR would be performed by the residuary mechanism branch for the continent of Africa, and all the uh, residuary functions of ICTA would be performed by the residuary mechanism established at The Hague, Netherlands. So the one at Arusha was established in 2012, and The Hague mechanism was established in the year 2013. Now, the tracking and arrest of certain fugitives now fall upon the residuary mechanism. So, in fact, 6 fugitives were at large, and the ICTR could not find them. Although the mechanism is in place, they were difficult to find. And these fugitives who were wanted for trial by ICTR have been the top priority for the mechanism. Top priority for the mechanism in the sense the mechanism wanted to, under any circumstance, identify and arrest those accused and then bring them before the mechanism so that they can be tried. Now, the 6 accused indicted by ICTR have been at large. They could not be found. Now, the mechanism functions on the basis of a statute that is established. So, under Article 6, Clause 3 of the mechanism statute, the mechanism shall only retain jurisdiction over those individuals who have been accused of committing the gravest of crimes. There could be, say, about a dozen people accused, but all may not have committed the gravest of the crimes. Only a few might have committed. So, under Article 6, Clause 3 of the statute of the mechanism retains jurisdiction only over those individuals who have been accused of committing the gravest of crimes. And in fact, the mechanism for ICTR at Arusha, the prosecutor requested referrals to Rwanda in case of 5 fugitives. In the sense, these fugitives were not guilty of committing the gravest of crimes, so the mechanism did not want to try them and referred them, sent a referral to the government of Rwanda, saying that let the local courts in Rwanda try these 5 fugitives because they are not accused of committing the gravest of crimes. However, the mechanism at Arusha retained jurisdiction over 2 of the fugitives, the accused. because they were the main persons who were guilty rather of committing war crimes, genocide, and crimes against humanity. And these two were Felician Kabuga and Proteas Mapiranya. These two persons were to be tried by the mechanism because they were guilty of committing the gravest of the crimes. Now, in the case of ICTY, the last two fugitives, in the case of ICTY, where the same mechanism has been established at The Hague, and two fugitives who could not be found and who were eventually found were Ratko Mladic and Goran Hadzic. And although they were to be tried by the mechanism, but yet the ICTY still existed at that point of time. Despite the mechanism being in place, the ICTY also existed. And these two accused were also tried by the ICTY, and the ICTY had completed its mandate totally. So, in this manner, we see that the mechanism that has been established by the United Nations organization was mainly to arrest and punish those accused who could not be punished by the two criminal tribunals. Now, a question may be asked by any of the panelists as to why, when in 1998 the International Criminal Court was established under the Rome Statute and it came into force. And if the two criminal tribunals, the temporary tribunals, ICTY and ICTR, were to be wound up, these criminals could have been referred to the ICC.
Yeah.
But there is a problem. There is a technical problem. The technical problem is these people were accused of committing crimes in the early 1990s. And as per the statute, Rome Statute, the court can try crimes only that have been committed after the statute coming into force.
Yeah.
Since these crimes were committed much before the coming into force of the ICC statute, the ICC cannot take up these crimes. So that was the reason why the United Nations decided to establish another separate mechanism for trying the remaining accused persons.
That's ratio temporis.
This is my submission as far as the residuary mechanism established by the UN is concerned. Thank you very much for giving me the opportunity.
Thank you, Professor Shipati, for your excellent presentation about the MICT. Professor Milton, do you want to add something about Professor? Okay, you have the desk. Go ahead.
Yeah, thank you, Dr. Marota. First of all, let's welcome Councillor Brian Ramapane. Are you okay?
Hello, Brian.
Brian? Nice to see you.
Hello, Brian. After a long time.
After such a long time.
We understand you had a challenge with your network last week. Okay. Can you hear me now?
Yes, I can hear you, sir.
Okay. Thank you, Professor Dr. Marota. First of all, thank you for handing over the responsibilities to me to be able to express what I have. And thank you, Professor Dr. Dwarakanath. I think you've covered very substantial part of the key aspects of the international residual mechanism for criminal tribunals. I'll try to touch the other areas that I feel would also be necessary to reinforce what you've already. And I like that last question that you posed. It is a question that will linger into anybody's mind that really, if we now have the regime of the International Criminal Court, why should we still have a mechanism in place dealing with criminal matters internationally while there's an ICC? It was well explained that the ICC operates in terms of jurisdiction, ratio temporis, in terms of only those acts which offend the statute after the statute was passed, after the ICC came into effect. And most of these other cases that were being handled by the ICTY and ICTR, as explained by the professor, were carried out long before the ICC came into place. The professor explained very well the background, giving the overview of what transpired and led to the formation of I'll just use the term IRMCT in short, for International Residual Mechanism for Criminal Tribunals. As he said very well, in 2010, that's the 22nd of December, the United Nations Security Council via resolution 1966 brought into existence the mechanism to be able to deal with residual issues that were overflowing from the two tribunals. I just want to add on something. Apart from the seats in Arusha, which essentially deals with the remnants, the residue of the ICTR, that is the International Criminal Tribunal for Rwanda. We have, of course, also apart from the one that deals with ICTY, which is based at The Hague, it is critical to note that there are instances where the trials are proceeded in a different place from these two. And that is, we've had a case where trials have taken place, for instance, in Europe. But those are exceptional cases. The operations, the seat remain those two critically. So the other thing I want to add is the rationale for having these seats in those two places was to be able to curtail on the costs. The costs were escalating. The cost of maintaining those two tribunals was escalating, and that was a major factor of having to wind them up. In fact, they should have been wound up long time. The United Nations Security Council was eager to have these two tribunals wound up long time, but each time they sought for extension, and eventually they got wound up. But the basic concern was the costs entailed in running them. And so the reason we have these two located where they are is essentially proximity to the area to the locus in Kur, where the crime was committed. Like the Arusha is very close to Rwanda. And so it deals with the remnants or the residue of whatever transpired during the ICTR. And so it's easier. It avoids also costs of movement of counsel across the continents just to deal with the same. So that was the rationale of maintaining the two branches anyhow. And as we can see, the rationale advanced by the United Nations Security Council was to ensure that there's a smaller, just as the professor put, a smaller and more efficient staff that should be able to deliver justice efficiently. The other thing I want to deal with are the organs of the mechanism. Let me use the word mechanism to refer to that whole long word of international residual mechanism for criminal tribunals. So when I use mechanism, I'll be referring to that. We have three principles within the mechanism, and that is the president, the prosecutor, and the registrar. The president is basically the head of the mechanism and is a judge, is appointed by the Secretary General, with the United Nations Security Council being consulted, as well as the other judges of the mechanism. We have the prosecutor who is nominated by the Secretary General, but appointed by the Security Council. We have the registrar who is appointed by the Secretary General, but basically it deals with administrative, policy, diplomatic support services to support the other two principles. To support the functions of the chambers, to support the functions of the judges and the presidency. So those are the three principles. Principles. I'm talking about principles with AL. The key, personalities within the mechanism. Okay, the judges are elected by the General Assembly. How do they elect judges? It's the General Assembly that elects the judges from a roster that is prepared by the United Nations Security Council. And they're elected for a term of 4 years. Usually, they can be reappointed after the 4 years, and if necessary, that is done by the Secretary General of the United Nations in consultation with the President of the United Nations Security Council and the General Assembly. And another interesting thing to note is that these judges operate not in a conventional way. They've been operating remotely. Remotely in the sense that they only appear at the mechanism when really needed, when necessary. But they can operate from wherever they are, in whichever country they are. That is something that is not common. We don't have that with the ICC. I think they preempted the Corona period. They started operating remotely a long time, and they still operate remotely in the sense that they are not stationed in Arusha or The Hague most of the time. So judges are wherever they are. They can operate electronically, but only when necessary, when they have to appear and preside over a matter, that's when they have to fly or travel to their seats. Okay, having talked about that, I want to brush through the other functions. Again, Professor Sripathi dealt with a number of functions. I just want to reinforce on what he has presented. He dealt with the fugitives. That was the key factor. There are still outstanding issues which are residual in terms of the fugitives having been at large. So it was critical to be able to maintain a residual structure that would handle the arrest if there was an arrest of those fugitives. As the professor indicated, the ICC would not be competent to deal with any of such fugitives because the alleged offenses were carried out way behind before the ICC itself came into existence. So the mechanism has the duty to track and prosecute the remaining fugitives. It's not just prosecuting, but also to track them. That's under the purview, under the responsibility of the mechanism. Okay, apart from that, we know that there are appeal proceedings that would arise. Some of the appeals had to be dealt with. The appeals that were made against decisions or appeals that were contesting the decisions or judgments of the ICTY and ICTR. But now, even now, we have other appeals that are brought in regarding the actions or decisions made by the mechanism itself. So we cannot just have the mechanism wind up and go while there are still outstanding justice issues to be addressed. So an example of this, we have the Mladic case, which was still standing and outstanding rather. Then we have, apart from the appeals, we have review proceedings. There are instances where one would want to review the judgments, not just appeal, but review based on certain facts, which have new facts that have emerged. Just to ensure justice, there has to be a tribunal to handle this kind of review. And the review can also be in respect of even the appeal. If the appeal had been exhausted and the convict is serving sentence, and during that serving, there emerges a new fact which would alter entirely the conclusion or judgment of the earlier court, then there has to be a tribunal to be able to deal with that review issue. And that's why the mechanism is there. We have had cases of retrial, but just to underscore, this review is in terms of decisions not only made by the ICTR and ICTY, but also those that the mechanism itself, the mechanism has been active, and anything that it has made also would be subject to review. It also deals, the other function is to handle retrials. There are instances where cases that were handled by the ICTY, ICTR, and the mechanism itself would warrant retrial. And therefore, there has to be the mechanism to deal with such issues. Apart from that, there's also need to deal with instances that arise in the, like, for instance, the contempt of court, or where perjury has occurred, where testimony has been overtly untruthful, deliberately meant to mislead the court. So the mechanism has the jurisdiction to be able to handle that. There are instances before the ICTY and ICTR wound up. There were instances where cases were referred to the national jurisdictions. Article 6, paragraph 5 of the statute of the mechanism empowers the mechanism to monitor those cases. You remember that in the Rwanda case, we have cases where 5 cases, like the ones were referred to Rwanda. We have instances where some cases went to France. So it is critical that there has to be a judicial authority to be able to monitor the progress and the international standards that are ascribed to those cases wherever they are. And so it is the duty of the mechanism to be able to oversee those cases. That is one of its functions. So whatever cases are outside that were sent there by the 2 tribunals now fall under the mechanism to ensure that justice, the accused and the victims, all the parties are afforded justice in those national jurisdictions. Apart from that, we have, in the case of the ICTR and ICTY, there were victims and witnesses. Actually, some of the witnesses were victims, and the other way around too. So these ones were afforded protection. There were a total, it has been estimated that there were a total of about 7,000 witnesses between these 2 tribunals. And 46% of all these witnesses were granted protection measures of some kind by the tribunals. So it is incumbent upon the mechanism to monitor, because there are instances where they have to alter the protection measures that have been given to the witnesses. You might find that there are instances where one would not need to be in a particular place. And so there has to be a particular judicial institution to vary those orders. And that is one of the functions of the mechanism, to be able to deal with the protection measures and try to alter where necessary, and to deal with any upcoming issues that affect the protection of the victims and witnesses. The other function was supervision of the enforcement of sentences. You know, when the ICTY and ICTR did sentence a particular convict, they would be taken to a given state and enter into an agreement. There are particular states that offered and would enter into agreement to be able to provide custody, detention for those particular convicts. It is up to the mechanism to be able to monitor, to see that those particular states are maintaining international standards in terms of detention. They are acceptable international standards, and which are incorporated in the signed agreements with the tribunal. So it is the duty of the mechanism to ensure that those particular states, the condition of the detainees or the convicts in those states are within the principles, within the parameters of the acceptable international standards. So the ICTR, we have records that the ICTR, some of its convicts were sent to Italy, Sweden. ICTR, the Rwanda tribunal. We had in Africa, they were sentenced and detained in Mali, Benin, and Senegal. The ICTY had most of its convicts sent to Norway, Sweden, Finland, Denmark, mostly in Europe, Poland, UK, France, Germany, Austria, Italy, Spain, Portugal, Estonia. Okay, so it's clear that it's critical that the standards are maintained for those particular detainees, wherever they are, and it is the duty of the mechanism to supervise such detention. Another function that the mechanism carries out is the assistance to national jurisdictions. The mechanism provides technical assistance and advice that the other national jurisdictions would need. For instance, it would be able to offer technical expertise in terms of what it has dealt with or what the other tribunals have dealt with. It may also offer advice in terms of witness protection. And there are instances where we've had requests to the OTP of the mechanism on particular issues or particular documents where they might need certified copies of court records of the ICTY or ICTR. It is the duty or the function of the mechanism to be able to deal with that. As Professor Sripath indicated, it's also a critical function to manage and preserve the archives, because the documents here are property of the UN. The documental records of all the transactions in the court are property of the United Nations and the IMCT. So those are the key functions which I just wanted to reinforce on what Professor Sripath had put across. However, there are a lot of questions that come in. One would ask if, this is a question that I'm putting across in conclusion, if we say that one of the key reasons is that the fugitives are still outstanding, and that there should be a residual function to be able to pursue and prosecute those fugitives. Does it mean that for as long as those fugitives are outstanding, the mechanism continues to exist perpetually? That could be a question that one would want to address. And also, for how long? What is, because that could be answered by one issue. One could answer that by saying after every 2 years, beginning from 2016, the United Nations Security Council is supposed to review the position of the mechanism, whether it should still proceed. And I take it that during that review, they would consider the issue as to whether the mechanism should continue or not. Thank you very much, ladies and gentlemen. Ladies who are listening, they may not be here, but they're listening in the background. And thank you so much, Professor Sripath, Dr. Marota, and Councillor Brian for listening. Over to you, Dr. Marota.
Okay, thank you, Professor Milton, for sharing your ideas and deepening also the information that was shared by Professor Sripath. What I would like to talk a little bit here is something that was during my research related to this summit that we are, was something that is very common in the German, Spanish, and Latin American criminal law doctrine that is named the enemy criminal law. So after doing a little bit of research, I found an interesting paper by Yvonne McDermott titled Fairness Before the Mechanism for the International Criminal Tribunals. I recommend this paper. It's very interesting approach. And there was something that I, as a former master student, it was related to nebis in idem and res judicata. So I will start a little bit my presentation with this title of Hans Kochler book. Its name global is related to international criminal law. Um, uh, so it's global justice or global revenge, international criminal justice and the crossroads. I think that right now, under the topic we are discussing, we are over this statement that he wrote. I guess it's going to be 10 years ago, and is when it was first published. This book, from Hans Koschler. No, it's going to be 70 years. The book was published in 2003. I thought it was 10 years ago, but no, it's going to be 17 years. So since 17 years ago, before we have the mechanism of receiving tribunals, it was a sense that um, the international criminal justice was at some points more than global justice. It was more a global revenge, and that's my point of view. I have that feeling also here, and I will start my speech with this statement that was used around the 17 between the 16th and the 17th century, that is hostis humani generis, that is very common in the law of the sea. And this hostis humani generis was about 21 years ago, was no 19 years ago. It was absorbed by Professor Gunther Jacobs from Bonn University. uh, Gunther Jacobs, in 2011, he refers this to the enemy criminal law, the Feinstrafe, as the Germans used to name it. The first time he discovered this was in 1985. That he discovered that there was a phenomenon in the EU and against how some crimes were prosecuted. For example, terrorism. He used the example of Great Britain. A terrorist detainee in 1980s, he could be without any legal assistance be detained for between 15 and 20 days. Even though his lawyer of this terrorist wants to present an habeas corpus, because according to the law, you can only be detained 24 hours without any indictment or accusation or investigation, even though that this kind of laws began to appear because we as society need to protect with these enemies that were attacking us and try to destroy the standards of levels that we used to see in our society. So, so here I bring this. So after reading this paper, it reminds me that about related to the Nevis in idem and Reggio Judicata to the retrial of the trials. Because if you see for the MICT for the cases that they are now dealing from the former ICTY, um, this um, this um, this legal defense was brought by the legal defense of, I think it was in the case of Simatovic. And they tried to use this one, the Reggio Judicata and the Neves in idem arose because of the court trial, extended beyond those obligations successfully. The prosecutor office use and try to analyze them. So here, what I see is that if we had in the past, or we have in the past, a tribunal, and beyond any reasonable doubt, all the evidence that were challenged, and the court decided that there was no enough evidence for the retrial of for given a sentence or a final judgment to these international criminal perpetrators. And then they tried to analyze once again that attempt, in my point of view, to one of the principles from one of the constitutionals that is in every constitution around the world. that is nebis in idem. You cannot be tried, or in English that is known as double jeopardy. That you cannot be tried for the same from the same accusation with the same evidence and with the same person. It's illogical, because that can play. Also, it's how do you say, it's a weapon with it's a blade with two, it's a blade with two shapes, that can cut that even uh, this philosophy of retrial and retrial and retrial, it's like an ending loop. I mean, because the idea of bringing justice, trying to go to court, is to at some point this must be ended. This happens in national courts, and also happens in the ICC. But if there's going to be another judicial organ that is going to analyze what the other did, I mean, that's the reason why there is an appellate court. But I mean, after 20 years, or that appears new evidence, or they try to at some point manipulate or trend the evidence to some point to retrial someone. In my opinion, that's a kind of enemy criminal law, because I know you are trying to put behind bars the criminal by using going not to the fairness of due process. You are trying, we as a society, we are not giving the accused the rights to defend himself. What I see here is more like going back to the Middle Ages, to the Saint Inquisition. You were accused of witchcraft, and you practically, it was a mockery. You see the face of the Christ and say, yes, you are like a puppet. You are the one that's going to be burned out. So I see here, it's more like we try. The problem here is, and that's our job as scholars, is to analyze and to give our opinions and to be like observers, and to see how to improve this. Because also this plays against uh, of of all this effort that in the past, since the Nuremberg trials, trying to fight for human rights justice, you give ammunition to the other ones that wants to destroy all that has been built. For example, the Hoyle book that it's I will pass it to Professor Milton. I have already the copy. That is, I will pass it to him so he can share with all of our friends here. I have the name. One moment, please. The name of the book that they have passed me right now is it's Justice Denied. It's from the author is David Hoyle. David Hoyle or Hoyle. I don't know how the pronunciation of his last name. I don't know if he's French or he's so in this book, that you will see that he used a lot of elements to try to say that, for example, the prosecutor office of the ICC is biased, and they answer more for a political ideology rather than to the fairness of justice, and to prevail the international restorative justice. And he uses some arguments of what this international mechanism tribunal, Reseal Tribunal, have been doing, of the retrial, and from point of view of many scholars, these attempts to the due process and to the liberty of how the law should be administrated. So, for summing up, it's very important that now that we are challenges. We have a new challenge. We are going to have a new a new indictment for a new international criminal probably next year. We hope so. That's going to be Maduro from Venezuela. The investigation from the UN has finished. So we need to be like observers that this new process of this new international criminal, in every level of his trial, I think it's going to happen. that he's going to have the quality of arms to defend himself, and um, so that's what I want to discuss here: the due process, quality of arms, and the trouble that some papers from some scholars, for example, this one from Yvonne McDermott. That's the reason why, well, when we started, I start with the question: do you see fairness before the mechanism from the international criminal tribunals? Because many scholars are challenging this. They don't see, someone see, someone's not see that there is a kind of fairness to continue. Also, but this is that we can discuss this in another moment. But I bring this idea to the desk. It's that some, well, this is my lawyer evil thinking. So I see it like they that at this point these judges, these prosecutors, they try to perpetrate the work per secular secularum to the infinitive. Yeah, I mean, they try to change the name, and we are going now. We finish with the mechanism, so so we can continue working. But yeah, that, and also there is a discussion of many in many social legal groups that they see that in that way for especially not the scholars but more the practice lawyers that are the one that go to court and they try they don't do much reading. They use some information, for example, if there's a violation of human rights in the process, and they use and they call that. But what I see here is we are scholars. We know how this works, and we try to give this information. The communication is very important. So that's the business here. We need to give the communication at every level, and also the UN needs to bring that communication, because if we see in these past 20 years, the book of this professor, it was in 2003 and beyond. I think the UN and also the ICC and this residual the mechanism, this residual mechanism for the international criminal tribunals, I think they don't have made in the past the real communication, and all this trouble related to fairness, to res judicata, to neves in idem, has given them the other part. I mean, the dark side of the international community, this ammunition for attack, the work and all the work in international criminal justice have been done since from Africa, Europe, Asia with the Khmer Rouge, and now that we are seeing also the Rohingya are trying, try to move a little bit the effort that is that the international community is trying to hand, no, not to hand is not the question. It's not the good word, because I'm using like, I mean, like be part of the same inquisition. It's not the hand. It's doing the work as a prosecutor must need all the elements to give to take someone to be tried, to take to justice. Also that needs to be changed here in the mechanism for the international criminal tribunals. It's also the defense lawyers. I mean, there's a need to have a very good defense and not so much pro bono defense, because also that it's giving the money to an NGO that will use the lawyers for defending the criminal. It's for me, my point of view is bias also. I mean, you need to be more transparent about that and to give the quality of farmers the same preparation that the prosecutor office has, the same preparation for defending, even though that according to the evidence, this person was an international criminal felon. We need to it's like a football match, and we need to play in equality. I mean, we need to play in okay, one will be better than the other one, but it's the same. They in the field they go 11 to 11. They have the same gears, the same soccer boots and everything. It's the same in the legal defense. So that's what from now on. what if in respect of this mechanism of these international criminal tribunals, I don't know when they are going to end. I hope so in, I don't know, 10 or 15 years, because if we close this for the work they're doing, I mean, we are going to say that international justice prevailed. But if they are going to continue for 20 years more, I mean, at some point, it doesn't have sense. Uh, so that's what I see here. So also I want to my fellow panelists, from the point of view, from not the legal scholar that we have, but from a point of view of a practitioner lawyer related to due process. It could be Professor Milton, it could be Brian, it could be Professor Shipati. I want to hear their point of view related to due process, related to nebis in idem in these mechanisms for the international criminal tribunals, related to retrial, for the retrial, because they can retrial. So what do you think? Professor Milton, Professor Shipati, or Brian?
Thank you very much, Dr. Marota. That's a good question. Just to reinforce, before I get into that, I would want to indicate, as I said, in retrospect, the United Nations Security Council reviews the status of the mechanism after every 2 years from 2016. So the review was carried out in 2018, and we hope that there'll be another review this year. I should take it, it's my humble submission that that process actually addresses some of the concerns that we have as a panel, or the other practicing lawyers have, who might think actually the mechanism is just trying to perpetuate some kind of job for a clique. So the Security Council reviews, and I think they would come up, since they created the mechanism, they would be able to come up with a solution when they feel maybe there's only one fugitive left. That would not justify probably the mechanism existing. But I would suggest also we hear from Brian Ramapalta before we step in, so that he has enough time to make his presentation, if that's okay with you, Dr. Marota and
Yes.
Professor Sipathy. And Brian, is it okay with you? You can make your presentation.
Thank you
Then
very
we can
much.
go into the discussion so that we are not cut off.
Yes,
We have
thank you.
actually only, we have about 17 minutes left.
Mm-hmm.
Yeah.
Thank you very much. I only have one question. With regards to the Rwanda Tribunal, because what I've always been meaning to understand is the efficiency of these mechanisms and whether or not they've been efficient since they've been established, looking at the atrocities that happened in Rwanda, and looking and when we look at the reviews that have been made by the Security Council, were those issues addressed? Thank you.
Just to make it clear, you asked about the issue about the efficiency. Let me just get it clear myself. Maybe my colleagues got it. You asking about the efficiency of the mechanism.
Yes.
Just elaborate a bit so that I get the precise question.
The question is, ever since the mechanisms were established, how efficient are they in terms of looking at the atrocities that existed, or because they were created because of atrocity that, for example, the atrocities that happened in Rwanda. So my question is, are the mechanisms efficient? And if they are not efficient, why are they still kept? Or why are they not disbanded?
Good question. I think my colleagues will handle that. Professor,
Okay.
Do you have an answer, or Dr. Marota?
Yeah.
Okay. Okay. Go
May
ahead,
I?
Prof. Yeah, go ahead, Professor.
Question posed by Brian is very pertinent. because the mechanism was established for a certain purpose. This question is whether this purpose has been achieved by the mechanism from the time it was established, that is in the year 2010. Now, what I would like to tell Brian is that the mechanism, when it was established under Article 6, Clause 3 of the Statute of the mechanism is entitled to exercise jurisdiction or retain jurisdiction only in respect of those individuals who are accused of committing the gravest of the crimes. In respect of other individuals who are not accused of the gravest crimes, the Arusha Tribunal in Tanzania had referred these fugitives to the Rwandan government, asking the Rwandan government to allow the national courts in Rwanda to try those persons. However, the mechanism in Arusha retained jurisdiction over two accused or fugitives. I mentioned the names also. Felician, it just got out of my mind. One is Kubago, Felician Kubago, and the other is Proteus Hiranya. Now, these two persons in Rwanda were accused of committing the gravest of the crimes, and the mechanism retained jurisdiction over these two fugitives and tried the two fugitives. So, in that sense, if you see Article 6, Clause 3 of the statute, the jurisdiction of the mechanism is somewhat restricted only to the gravest of crimes. It cannot try individuals committing other crimes. It's a restricted jurisdiction. So within the confines of the restricted jurisdiction, the mechanism has been able to achieve its objective. That is what I would like to say.
I think that's a very good response. Maybe Brian will comment on that. Mr. Ramapane.
Thank you very much. I don't have any comment. The question that I wanted to ask is from the fugitives that were accused of those war crimes, was the court firstly can it be submitted that it was efficient in doing its mandate?
Oh, that's the question.
Yes, because I understand that some were prosecuted, right? But in terms of the purpose
from your speech
of the mechanisms, was it fulfilled to the core?
Okay, I believe Professor Sipathi did something about that, but I would also want to make a comment. To be able to understand whether there has been efficiency in dealing with the referral, we need to look at the mandates of the court as of the mechanism. The mechanism is actually an international court. That is the characteristic of it. So we would have to look at the mandate that it has. When we look at the mandate that was conferred upon the mechanism, it goes much more than just dealing with the matters relating to prosecution of the fugitives or other convicts, other suspects brought before it. So for us to be able to examine the efficiency of the mechanism, it would, because when the mandate was granted by the United Nations Security Council, it was essentially that this particular mechanism was supposed to continue the jurisdiction, the rights, obligations, and essential functions of the tribunals, the ICTY and ICTR. So you can see that it was not just the issue of jurisdiction. There were other rights that were supposed to be perpetuated. There are other residual obligations and other functions which go much way beyond just dealing with particular suspects. As you'll note, when I gave the functions, they were running to almost 9 of them. And majority of them had very little to do with actually prosecuting the accused. It's because in nature, essentially it is a residual institution in the sense that it deals with any other matter that was left over because the principal entities that were supposed to handle this were wound up and they could not just fold up and leave. There are other things that had to spill over. So like the archives, you can see, these are just functions that reflect folding up. They are closing down. So for me, to deal with the issue of efficiency in any of the functions of the mechanism, and I believe that is what the United Nations Security Council looks at when it considers the review, like it did, it will do this year. I'm not sure that's already done. I'll check, but I think it's to be done every 2 years. To be able to look at those particular questions that you've asked. It's a very critical question. And in my view, they would have to look at all those other functions to see whether the mandate, the whole mandate, because that mandate was summarized in the provision in that resolution 1966 that was passed on the 22nd of December 2010. The aim was to be able to have, because the ICTY and ICTR were very expansive in nature and very, very costly for the United Nations. So as a consequence, they wanted it closed down so that they have a small temporary, that was made clear, small and temporary and efficient structure. So the question you brought is very important because efficiency was foreseen. The importance of efficiency was very critical for the United Nations Security Council. That's why it said we want a small, temporary and efficient structure whose functions and size will diminish over time. So the Security Council oversaw that with time, actually, they should even be able to drop down some of the staff. Some of the staff would be out of way to reduce it, but still maintain the efficiency. Now, how they monitor the efficiency, I believe they have a parameter. When the review is being presented, they would have a standard point through which they would measure whether there's been efficiency conducted. But in my view, I don't think the efficiency would revolve basically just around the functions of the ICTY, the defunct ICTY or ICTR. It would be in light of the new mandate that was granted to that particular mechanism. So unless somebody else has some other thing to add on, but the number of staff would be commensurate with the reduced functions, because the functions they were reduced in the sense that they foresaw that the functions even of the mechanism would continually get reduced. The aim is in the long run, there should be complete seizure of this particular trend of action that flowed from the ICTY and ICTR for that matter. All right, maybe I can see Professor Sripati wanted to add something. Go ahead, Prof.
Yeah, I would like to add something to this discussion. Not exactly regarding what Brian, probably it's a kind of an idea, a suggestion. Now, if you consider the statute of the International Court of Justice, it is considered to be an integral part of the United Nations Charter. And under the statute, the International Court of Justice exercises 4 kinds of jurisdiction. One is voluntary jurisdiction. Secondly, compulsory or optional jurisdiction. Thirdly, advisory jurisdiction. And fourthly, transferred jurisdiction. So let us keep aside the first three jurisdictions and focus on the last one, the transferred jurisdiction. What is this transferred jurisdiction? Transferred jurisdiction is that jurisdiction which has been transferred from the Permanent Court of International Justice that was established under the League of Nations to the International Court of Justice. When the League of Nations was dissolved in the year 1939, when the Second World War began, the statute, the court also was dissolved, the Permanent Court of International Justice. So there is a procedure as far as the statute of the Permanent Court is concerned and the statute of the International Court of Justice is concerned. Now, the provision under the Permanent Court of International Justice is that states confer jurisdiction upon the court for a certain period of time, say 10 years. Suppose, let us assume two states, A and B, have conferred jurisdiction upon the Permanent Court of International Justice for a period of 10 years. Probably in the year 1935, these two states have conferred jurisdiction. So the court will exercise jurisdiction in respect of these two states for a period of 10 years, from 1935 to 1945. Now in 1939, the Second World War began, the League of Nations was dissolved, so also the court. So the court was able to exercise jurisdiction only for a period of 4 years, whereas the jurisdiction conferred by the two states is for 10 years. So balance 6 years is now transferred to the International Court of Justice when it was established as a principal judicial organ of the UN in the year 1945. So ICJ will now exercise jurisdiction over those two countries for the next 6 years. This is what is known as transferred jurisdiction. So in my opinion, since the statute of the International Court of Justice being an integral part of the United Nations Charter, why can't the UN think of such a plan or an idea of transferring the jurisdiction of the two criminal tribunals, ICTY and ICTR, to the ICC, so that the mechanism can be eliminated. That way, the UN would be saving a lot of money because the ICC is in place, it is functioning. However, a small amendment has to be made to the statute of ICC. So this particular transfer of jurisdiction to the ICC must be considered by the United Nations Organization or the Security Council as a one-time case, as an exceptional circumstance. There should not be a blanket transfer of jurisdiction of all cases to the ICC. It's a one-time case, exceptional case, where the UN can transfer the jurisdiction from the temporary tribunal to the ICC. So this can be done because the practice has been there in respect of the Permanent Court of International Justice and the International Court of Justice. There is a provision under the statute of ICJ for transferred jurisdiction. So the same mechanism can be tried by the UN. So that is my submission.
Okay, now that's really a good suggestion. But now I think that deals with the issue of the regime temporis, of course, the jurisdictional aspects of time going beyond when the court.
Yeah, that is why I said it should be considered as a one-time case, an exceptional.
I totally agree. What I'm just trying to advance a point based on your point, in the sense that now it would engage the ASP, the Assembly of State Parties, would be critical in this process of the amendment. But I have a feeling that would have two sides to this debate, of course, within the Assembly of State Parties. And most of the members of virtually all the members of the Assembly of State Parties are also members of the UN.
Are the members of the UN.
Yeah. Although now at the UN, we may not have all those members of the UN are not necessarily members of the ASEAN.
Members of.
We might face resistance from countries like the United States itself that might look at such a suggestion as trying to provide a loophole for their system that they've been fighting all along, to have not any American brought before the courts, the international courts. I'm not disputing your suggestion. I think it's a very good one. I also looked at it that way. But I'm just looking at the other side, that we are bound to have also other arguments contrary to the position. So if we advance that kind of suggestion, I think that would really, as you said, reduce the expenses that come
Yes.
from the UN. That's a very valid reason. Maybe some of our colleagues would have something to add. I know it's already time. We can have one more minute, then we wind up. Thank you, Professor, for that suggestion.
Welcome.
Yes, Dr. Marota.
Well, what Professor Shipati, I shared the idea with Professor Shipati using the ICC of transferring for this. Yeah, that's something that many, when I was at my master, everyone of my peer asked why we need to have residual tribunals if we can use the ICC as the International Court of Justice was used to continue what just explained by Professor Shipati. And this reminds me, in some countries there are the liquidator courts. For example, I was doing some research here in Lima, and they change their criminal legal system from a more adversarial one. They introduced in 2004 a new criminal procedural code that the judge, that there was no judge participating in the trials, only like an adversarial system. Nevertheless, there were some cases that were used with the old code, and these cases are now, some cases are going to be ended in this year, and there are some courts I call the liquidator courts. So there are specific courts that will continue with the other old system, because the new one cannot apply, because the new one, according to this principle of nullum criminal sine lege, is come from 2004 beyond. So this began in 2004, and last year it began by blocks, by province in Peru, and last year it holds all the Peruvian counties. But it was a very small, it was a very productive process. So I think this is a very good approach. That, and that's bring me my other question that I brought you before, that is, if there was not some kind of perpetrating these judges and this prosecutor in time for more 10 or 20 years, and this is the argument used by the dark side of the force, you see Star Wars mottos from, yeah. So if we have the ICC, and in the past, as explained Professor Shipati, why we continue with this residual? We can reduce, and we can reduce a lot of money, and and this money can be used in other places. We have the ICC, we have the teams. Why? So once again, I think it's a little bit more of communication, trying to, I know that there is this eager to find justice, but we need to use the elements we have in hand, because for the special Lebanon tribunals, probably, I don't know if I don't know how I'm not doing any follow up to that tribunal that started in 2007. I don't know if there's going to be any if it's going to happen like the ICTY or the Rwanda courts. Probably we will need an MI mechanism for residual tribunal for that tribunal. So for that tribunal, we can use the what Professor Shipati has remind us all. So I think that's the trend for now on, for this tribunal that is going on, and for the future ad hoc tribunals that these hybrid tribunals that will be appeared. So I think that we need to further this many in our discussion. I don't know the proposal of the have done Professor Shipati have reminded us all. Thank you.
Yeah, that's a good introduction of another issue. When we talk about tribunals now, we bring in also the issue of hybrid justice.
Correct.
Yeah, there's a debate going on as to whether we should resort to hybrid justice more, being more efficient than the ICC itself. Actually, the Special Tribunal for Lebanon, essentially it was formed to deal with the Rafik, the
Yes.
case of Hariri, yeah, remember? And
Yes,
it
that's the
appears
point,
it has
right?
arrived at
Mhm.
particular decisions. But the
Mhm.
question would be, is that the only subject matter it has to deal with? There could
Yes.
be other issues that it has to handle that could come up. Don't you think some of these tribunals would be continually handling issues that involve atrocities? I think it's a good suggestion. All these need to be explored. So we need to look at the question of the hybrid justice and also look at the issue of the aim. The United Nations essentially brought in the mechanism to save costs, just like you said, and
Mhm.
Dr. Professor Dora Kanath. So I think these are issues that will be explored. It's highly debatable point that has to be brought forward. I want to thank everybody for coming through. Thank you, panelists.
Okay.
And we thank all the viewers, wherever they are, for having been with us today. It has been a very interesting topic. You have had all the intellectual discussions, very powerful questions brought in, like by Brian, and very good answers by questions by Dr. Marota, Dr. Sepathi, answering some of them. We thank you very much, panelists, for your participation. Thank you very much, our viewers. Until we
Thank
see you
you.
again next time.
Thank you.
Bye-bye.
Bye. Have a nice weekend. Bye.
Yes.
Wherever you are.
Bye.
Thank you.